As you people know that the major criminal laws have been replaced by new legislations with effect from July 1st, 2024. The nomenclatures of these new legislations are already in your knowledge, but still I am reminding you of the new names which the Parliament has chosen for the outgone old legislations. The Indian Penal Code of 1860 has now become Bharatiya Nyaya Sanhita 2023. The Criminal Procedure Code 1973 has now become Bharatiya Nagarik Suraksha Sanhita 2023. In short, you can call it BNSS. Earlier, we used to pronounce it as CRPC. Now, this new legislation will be pronounced, will be spoken and written as in abbreviated form as BNSS. The third legislation, Indian Evidence Act 1872, has now become Bharatiya Sakshya Adhiniyam 2023. In short, BSA, BNS, BSS, BSA. These are the new abbreviated forms, nomenclatures of our outgone old laws of British origin. Today we are covering in this session only a few provisions which have been introduced in these new legislations, especially in the BNSS, because you organizers required me to address you only the salient provisions relating to F.I.R, to arrest, investigation of crimes, remand, bail, inquiry, trial, and allied matters related with the major subjects. The first issue is what was the necessity, what was the compulsion of the Parliament which led them to replace the old criminal laws by these new Sanhitas. You know, like other laws, the criminal laws in India which were in force and which were being applied by police and courts in India were of British origin. The Britishers had enacted those laws not only for giving justice to the people of India, but also to suppress them, to control them, and to force them to carry out their dictates in order to continue their rule here over us. An idea was floated in the outgone this Lok Sabha that earlier the name of the IPC, which means Indian Penal Code, it meant to penalize the Indians, to award only penalties, punishments. So the idea was that the purpose of a law cannot be just to punish the citizens. The purpose of any law is primarily to give justice to the recipients of justice, to the victims, to those who feel offended by any act of others. So imparting justice is the primary goal that a law achieves. But the nomenclature itself of the IPC suggested that it was meant to award punishment to the Indians. Therefore, the Indian Penal Code was replaced by Bharatiya Nyaya Sanhita. Similarly, the procedural code, the old procedural code, that CRPC, which Indian Parliament has drastically amended in 1973, that came to be called as Bharatiya Nagarik Suraksha Sanhita. Word Suraksha has been added to it because this Sanhita, this code, is not meant just to provide procedure for the police, for the courts, but it also aims to provide protection to the life, liberty, and dignity of citizens and protection to the property of citizens. So when a legislation aims to provide protection to the interest of the citizens, then of course it could have been there could have been no any better name than this one, BNSS, Bharatiya Nagarik Suraksha Sanhita, because it provides now two things: Suraksha, protection to the citizens, to their life, liberty, and property, and also procedure to the courts and to the police who investigate the crime, who conduct the inquiries and trial, and who impart justice. Then third one is Bharatiya Sakshya Adhiniyam 2023. Earlier its name was Indian Evidence Act, but the Parliament has not given any English name, English version to this legislation. They have simply given it only Hindi name, Bharatiya Sakshya Adhiniyam, BSA. In tune with the objectives which the Constitution aims to achieve with regard to the language, uniformity of language, when there is uniformity of laws across the Republic of India, then of course, in the matters of legislations, laws, which are applied by the agencies and by the courts, they should also be uniform. Therefore, I think the Parliament gave this name to this previous Evidence Act, now in the form of Bharatiya Sakshya Adhiniyam, BSA. So these are three legislations which we will discuss today. A question arises, what is the date of applicability of these new laws? You know, these three legislations have replaced the previous three legislations, the IPC, the CRPC, and the Evidence Act. So, as has been notified by the central government under Central General Clauses Act 1897, the date of enforcement of these new three laws is July 1st, 2024. From this date, these laws have come into force. The question should be put, what will happen to the cases, to the applications, to the proceedings, revisions, appeals, and a lot of other matters, proceedings, which were already pending prior to July 1. So then there is a section in Bharatiya Nagrik Suraksha Sanhita, BNSS, and that section is 531. This section very clearly provides what would be the date and what cases would be covered within the new Sanhita and what cases would be covered within the repealed CRPC of 1973. So this section 531 of this BNSS says all those applications, proceedings, cases, inquiries, trials, revisions, appeals were already pending prior to the date of coming into force of this new Sanhita, that is July 1st. They will be covered by the CRPC of 1973. To simplify and to make it more clear, I again clarify it. All those applications, cases, and proceedings which are already pending in the courts or with the police officers up to June 30 of this year, CRPC will continue to apply to them. And those applications, cases which came to be filed in the courts or with the police on July 1st, they will be covered under this new Sanhita, BNSS. So let you be very clear in your mind in what cases the old CRPC will apply and in what cases this BNSS will apply.
So did you mention about section 531 of BNSS or BNS?
No, BNSS, Bharatiya Nagarik Suraksha Sanhita. It's section 531. You can consult it. It is available on Google also. Otherwise, you can have a bare act from the market. It's available everywhere. And in a cosmopolitan city like Bombay, I think it must be available even in the corridors of courts. So this section 531 quite clearly provides about the applicability of old CRPC and the applicability of the BNSS. To be accustomed to use this term BNSS. Otherwise, so far we are quite comfortable with the term CRPC, IPC, but now it will take some time to be comfortable with these new terms, with these new nomenclatures given to these new legislations. BNS, Bharatiya Nyaya Sanhita, BNSS, Bharatiya Nagarik Suraksha Sanhita. All those applications, cases, proceedings which are pending in the court up to June 30, CRPC will continue to apply to them. But those cases, those applications, etc., which were filed or instituted in the court on July 1st, this BNSS will apply to them.
Do the old laws stand repealed by the new laws? And if so, then how will the old cases be resolved?
Old cases which were pending up to June 30, prior to the date of enforcement of this new law. That means up to June 30. Cases pending up to June 30. CRPC will apply to them. It is written in section 531 itself. There is no ambiguity, no confusion, no room for any doubt, because section 531 quite clearly provides for this method of application of old and new laws. So whenever there is any doubt whether CRPC will apply to this case or BNSS will apply, you just consult which section? Section 531 of the BNSS. Now I am taking up the matter of arrest. You know, police and different other agencies have been given power of arrest of an offender who is suspect of having committed some cognizable offense or against whom an order of court has been issued for his arrest. Valuable warrant, non-valuable warrant. You know, courts are empowered to issue in suitable cases. And even if there is no such order from any court, police has been given this power to effect the arrest of a person who has committed some cognizable offense. Word cognizable offense is important. Earlier in the outgone CRPC, there was a section 41. This section 41 used to empower the police officers to arrest any person suspected of having committed any cognizable offense. I think everybody among the participants must be familiar to what offenses are cognizable and what are non-cognizable. Cognizable means where a police officer can arrest a person without warrant from court, without order of court. Non-cognizable means where police officer has no authority, no power to arrest a person without first having obtained a warrant from the court, from the magistrate, or from any other court empowered under law to issue valuable or non-valuable warrant. So this is the difference between cognizable and non-cognizable. So earlier section 41 of the CRPC had given power to the police officers to effect arrest like this. Then in 2006, CRPC section 41 came to be amended by the parliament. It said that normally, if an offense is not punishable beyond 7 years imprisonment, no police officer should normally arrest the accused unless he can record in the arrest memo the justification, the compelling reasons why the arrest is necessary. This was the amended section 41 of the CRPC. Now certain amendments have been made. This section 41 of the CRPC has been retained in BNSS with certain modifications, with certain additions and deletions. Now it says, yes, if the offense is not punishable by imprisonment of 7 years or more, so then a police officer should normally not arrest the accused. But if he still wants to arrest the accused, he should first seek prior permission of the deputy SP of that territorial jurisdiction of the police station. And only with his nod, the accused should be arrested. So still, even in offenses which are cognizable but which do not exceed in punishment beyond 7 years, police still has power to effect the arrest. But the only precondition is up to 7 years imprisonment, police will have to seek prior permission of the deputy SP of the area, and then they can effect the arrest. And they will have to record reasons in the arrest memo why the arrest was necessary, even if the offense is cognizable, non-bailable. But justification for arrest will have to be given in the arrest memo for perusal, for verification of the courts. You know, Article 21 of our Constitution says no person shall be deprived of his life and personal liberty except in accordance with the procedure established by law. So Constitution guarantees as fundamental right the right of personal liberty to citizens and non-citizens also. This one is the single article in our Constitution which is available even to non-citizens. If a foreigner comes to India and he is arrested here in relation to some offense, even in his case, police will have to record its reasons, its justification, why arrest was necessary. So is the case in relation to Indian citizens who are accused of some offense. So arrest memo Police officer will prepare the arrest memo, will record the reasons why he is compelled to effect the arrest. Even before coming of this BNSS into force from July 1st, the Supreme Court in many cases had ruled that merely because FIR was registered against some person for cognizable offense, it doesn't mean that the police should immediately proceed to arrest that person. Registration of FIR in respect of cognizable offense is one matter. Arresting or not arresting the accused is altogether a different matter. If the investigation of the crime can be made without arresting the accused, then police must not arrest that person. Or submitting a charge sheet to the court, arrest is not a precondition. Even without arrest, charge sheet can be submitted to the court. I remind you people of a case, a constitution bench decision of the Supreme Court given by it in the year 2014, and that case is Lalita Kumari versus State of Uttar Pradesh, 2005 Supreme Court, 5-judge bench, 5-judge. You always make a habit not to cite 5 judges. It's always singular, 5-judge. Whenever you write the strength of a bench while citing the case, the journal in your application, in your proceeding, in your order or judgment, you should write it F-I-V 5-judge, J-U-D-G, not judges, singular, judge, bench. That's why I'm just using that correct version which you should inculcate in your habit. It's a 5-judge bench, not 5 judges. 5 judges is wrong. It's a 5-judge, singular. When the strength of a bench in the Supreme Court is 5 or more, then it is called Constitution bench. When it is formed by CGI, when a provision of Constitution is involved for interpretation of the court. If the case requires interpretation of any constitutional provision, then a constitution bench is formed. And as per the Supreme Court rules, the strength of such a bench cannot be less than 5. It must be either 5 or in odd numbers, any higher number, 7, 9, 11, whatever. It depends upon the CGI, depending upon if suppose there is a larger bench, a constitution bench decision already available by a bench strength of 9 judges, and the law laid down in that 9-judge bench in the past is now being questioned by any bench, a reference will have to be made to the CGI for formation of an appropriate bench to reconsider the law that was laid down by the 9-judge bench in the past. Because you know, with the passage of time, the requirement of the society, requirement of the nation changes. And so changes the response of the courts. Then courts are called upon to come up with new formulas, with new laws, judgment laid down laws in order to meet out the situations of present day society and the nation. So then larger bench is formed. If 9 bench is already available and the law laid down in that old case has been doubted, then obviously it will be a larger bench, means 11-judge bench. Who will form it? CGI has the power under the Supreme Court rules. So is the position with the state high courts. The Chief Justice of the concerned high court will form a larger bench. Whenever normally it is a bench of 2 judges in the Supreme Court who sit, because as per the Supreme Court rules, a single judge doesn't sit to hear any case in the Supreme Court. It's a practice at the high courts, but not in the Supreme Court. In high courts, single judges sit and decide the cases, given the category, the type of case as provided in the rules of the concerned high court. But in Supreme Court, single judges do not sit singly. They at least 2 judges sit together in a bench. And if 2 judges sit in a bench in the high court, you know that bench is called division bench. But a bench comprising 2 judges in the Supreme Court is not called division bench. Many people call it double bench. That's wrong. A law student, a lawyer must be familiar with these basic things. Never say it, call it, write it, double bench. It can be so spoken by ordinary people in ordinary parlance, but not a law student, a lawyer, or anybody who practices the law or who is familiar with the practices of the court, with the composition of benches under the rules, whether in the Supreme Court or in the state high courts. I was just pointing out Lalita Kumari, State of Uttar Pradesh, 2014, 5-judge bench. In this case, this constitution bench had ruled in 2014 that normally a police officer should not proceed to arrest the accused merely because F.I.R for cognizable offence has been registered. If the investigation can be conducted even without arresting the accused, police officer must not arrest the accused. For arresting the accused during investigation, police officer will have to record reasons in the arrest memo to be prepared by him to why he was compelled to effect the arrest. The Supreme Court laid down certain guidelines to where during the course of investigation, police officers should arrest the accused and where arrest should not be made. As ruled by Supreme Court in Lalita Kumari, I am just pointing out when an arrest can be made. Number one, when the accused is not cooperating with the police, when the police is interrogating the accused, eliciting information from the accused under section 161 of the CRPC. The accused is not cooperating, he is not helping the police in working out the offense, the crime, the case. He is dodging the police, misleading the police. Then custodial interrogation is required. When the accused is arrested, he is brought to the police station or to the headquarters of the agency investigating the offense, and the person is interrogated into custody of the agency. Then chances of telling the truth, providing the clues to the investigating agency by the accused becomes higher. You know, there are many clever, cunning, and experienced criminals, offenders who dodge the police, who mislead the police, who do not assist the police in the investigation, do not tell, do not spell out, disclose the manner of commission of the crime, the people who were involved with him in committing the crime. In such a situation, it becomes necessary for the police officers to arrest the accused and interrogate him in custody. So that is one, custodial interrogation, if it is necessary. If the police officer records in the case diary, in its proceedings, yes, accused is not cooperative, unless he is interrogated into custody, he will not divulge the details how the offense was committed. Then a police officer would be justified in arresting the accused for custodial interrogation. In short, you should keep in your mind the purpose, the reason behind arresting an accused may be, number one, custodial interrogation, necessity of custodial interrogation of the accused. And number two, when there are chances that the accused will lead the police to make recovery of certain incriminating material like weapon, like money, like any other thing connected with the crime. So recovery of some article, anything, or any weapon, etc., that was used in the commission of the offense. So that can be the second reason. Making any recovery of any incriminating material connected with the offense. And number two, as I told you earlier, making custodial interrogation of the accused in order to elicit from him the truth, the details, which he is otherwise not telling to the police. So custodial interrogation is number one thing. Or number two, recovery of anything connected with the crime. Third one may be, so when the accused is threatening the witnesses, he is likely to destroy the evidence connected with the case, or to threaten the witnesses, or he is threatening the victim of the offense, which will ultimately adversely affect the investigation, then arrest may be made. Otherwise, if an investigation can be smoothly, properly conducted, there is no necessity for custodial interrogation of the accused. There is no necessity of recovery of anything connected with the crime, and the accused is also not involved in destroying the evidence connected with the case, not threatening the witnesses or the victim or his dependents, then arrest cannot be made. So I'm again pointing out, so when arrest can be made, number one, when custodial interrogation is necessary. Number two, when recovery of something connected with the offense is necessary. Number three, when for other reasons like threat, etc., by the accused to the witnesses or destroying the evidence, arrest is necessary.
अगर 30 जून के पहले कोई ऑर्डर आया है मजिस्ट्रेट का और उसे चैलेंज करना है, तो अब कौन सा लॉ एप्लीकेबल होगा?
30 जून को ऑर्डर आया है तो इट मीन्स कि वो ऑर्डर किस लॉ में आया है, नए में कि पुराने में?
सब पुराने में 30 जून के पहले आया हुआ है ऑर्डर।
ठीक, इट मीन्स कि दैट केस वाज पेंडिंग प्रायर टू जुलाई 1st. व्हाट इज कट ऑफ डेट? जुलाई 1st 2024, and the order passed by magistrate was passed in CRPC when case was already pending. When BNSS came into force on July 1, then that order will now be challenged in the old CRPC, because if you go into revision, if you go into appeal, go to the High Court under 482 CRPC, or even in writ petition or in any other proceeding provided by Constitution or by laws. So then 531, Section 531 itself says the case, the application, the proceeding that was already pending prior to July 1st, CRPC will apply to them. Revision, appeal, all these proceedings are just continuation of the original proceedings of the case. A revision is not an independent proceeding. An appeal is not an independent proceeding. Wherefrom it has arisen? If there would have been no original case, there could have been an appeal, there could have been a revision. No, not at all. Whether in civil cases or even in criminal cases, all other proceedings in the form of revision, appeal, or any other application that is made to the superior courts. Superior courts mean courts superior in rank to the lowest court or trial court, lower court, trial court. So all these proceedings, revision, appeal, etc., are just continuation of the original proceedings pending before the trial court. Therefore, in a order that was passed on June 30, this BNSS will not apply. What will apply? That CRPC. But what will happen if the case was instituted on July 1st and then order was passed by the court? Then CRPC will not apply, because case itself came to be instituted for the first time on July 1. Therefore, BNSS will apply. अभी एक FIR का एस्पेक्ट रह गया है, वो भी बोलते हैं. Earlier we had section 154 in the CRPC of 1973. Under this section 154, if the SHO of a police station used to receive information regarding commission of some cognizable offence, his duty was to register the FIR on a format provided in the police manuals of different states, and then investigations used to start. Registration of FIR is a precondition. But now a new provision has been added in section 154 itself. It says if SHO receives an information regarding commission of a cognizable offence which is punishable with lesser imprisonment than 7 years. The offence does not provide for imprisonment up to 7 or above 7 years. Then they say the police officer may inform the local deputy SP and may conduct a preliminary inquiry. And if after conducting the preliminary inquiry, after collecting some evidence to satisfy himself that yes, information received by him is true and arrest of the accused is necessary for proper investigation of the offence, then only he will register the FIR. Otherwise, if there is no evidence with regard to the commission of offence, then he will not register the FIR. This is the new provision added in 154. They have given another clause if the offence does not provide punishment for exceeding 3 years, and the offence is not exceeding 3 years, below 3 years, though the offence is cognizable and non-bailable, but there is no evidence in support of the information received, police officer can refuse the registration of FIR. With these modifications, new additions, the provision is the same. When cognizable offence information is received by commission of offence which is cognizable is received by the police, normally FIR has to be registered. And if the SHO refuses to register the FIR, then the provision is he should inform the superintendent of the district, concerned district, and he can direct the subordinate police officer to register. If even the superintendent of the district police doesn't direct the registration of FIR, then the option of the aggrieved person is to move an application under section 154 to the magistrate having local territorial jurisdiction over the concerned police station to register the FIR. Even a zero FIR can be registered. If some offense has been committed in Bombay, somebody sitting in Lucknow can register the FIR here. It is called zero FIR. This FIR will be transferred from Lucknow to Bombay police station, concerned police station. The matter will be investigated where the offense was committed. The provision for zero FIR was earlier there through court judgment. Now these observations, directions of the courts have been incorporated in section 154 itself, which has now become section 173 in the BNSS. For section 154 of the CRPC, the analogous section, corresponding section in BNSS is 173. There is a schedule given in the beginning of the BNSS. This schedule provides what is the corresponding section now in the BNSS for the old section given in the CRPC. Whenever you are in doubt which is the relevant section in the BNSS, that will now apply to the matter. You should go to the schedule given in the beginning of the BNSS. A table has been given in several pages, old section in CRPC, then in front of it, the new section corresponding the old section of the CRPC in the BNSS. That's not a difficult thing. You can very easily consult the schedule, the list given in the beginning, and you can find out which is the relevant section now in the BNSS for the old section in the CRPC. These are certain basic things which you must notice. Then there is a new section 174 in the BNSS. It says if the SHO has received an information with regard to commission of non-cognizable offense, then FIR won't be registered. What will be registered? This information will be registered with the police station in the form of non-cognizable report, because the information received by the police station does not disclose commission of cognizable but non-cognizable offense. NCR, in short it is called NCR, non-cognizable report. Earlier in CRPC, it was covered under section 155. Now this 155 of the CRPC has become section 174 in the BNSS. What is the difference between FIR and NCR? In the matter of FIR, a police officer can arrest the accused without having obtained a bailable or non-bailable warrant from the court. He can arrest if the necessity is there. The three necessities which I pointed out to you earlier. If any one of them is available, police officer can justify it in the arrest memo. He can, without getting warrant from the court, can arrest. But in respect of non-cognizable report, non-cognizable offenses, a police officer has no power to arrest the accused without permission of the court. He cannot even investigate the NCR, non-cognizable report, registered with the police, without permission of the concerned court, the magisterial court of the local area, which exercises the jurisdiction over that police station. So the same position was earlier also under section 155. Now the relevant section is 174. No investigation can be made in respect of NCR without prior permission of the court. You know, arrest is part of investigation. And if arrest is necessary, it can be justified. Then the investigating officer may approach the magistrate, local magistrate. He may convince the magistrate, may obtain non-bailable warrant, and then the accused can be arrested. But normally, in those offenses which are not punishable with 7 or more years imprisonment, arrest should not be. It should be very strong case, genuine case, where police officer must justify in arrest memo that arrest was necessary. Number 1, for custodial interrogation. Number 2, for recovery of things. Number 3, for preventing the accused from destroying the evidence, threatening the witnesses, absconding, etc., or committing or recommitting the same or serious offenses. So this is in short the provision regarding registration of FIR, regarding registration of non-cognizable report, investigation of cognizable offenses and non-cognizable offenses. What is the provision for registration, direction for registration of FIR by magistrate. Earlier under section 156, subsection 3, 156(3) in the CRPC was the provision empowering the magistrate to order to direct the police for registration of FIR or to treat the application as complaint case and himself proceed as magistrate proceeds upon receiving the complaint case. This power has now been given to the magistrate in the form of section 173 subsection 4. 156(3) क्या हो गई है? 173(4). ये सब आपको शेड्यूल से देखना पड़ेगा और शेड्यूल के बाद जाके उस सेक्शन में देखना पड़ेगा. Magistrate earlier used to direct the registration of FIR under section 156 subsection 3. Now that very power is vested in magistrate under section 174 subsection 3 or subsection 4. 156(3) has now become 173(4). The power is the same. Remand that was earlier granted under 167 by magistrate and now it is granted under 187 in the BNSS. The new section is 187 for remand. Old section was 167 in the CRPC. New section in the BNSS is 187. You know what is Article 22, Clause 2. No person accused of an offence after his arrest shall be kept detained in the custody of police beyond 24 hours. 24 घंटे से ज्यादा पुलिस किसी को गिरफ्तार करके अपनी कस्टडी में नहीं रख सकती. नियरेस्ट जो मजिस्ट्रेट है, जुडिशियल मजिस्ट्रेट है तो पहले उसके पास, वो नहीं है तो देन एग्जीक्यूटिव मजिस्ट्रेट के पास ले जाएंगे टू ऑथराइज हिज डिटेंशन. ये है. सीआरपीसी और बीएनएसएस पर हम बाद में आएंगे. इट इज द मैंडेट ऑफ द कॉन्स्टिट्यूशन इन आर्टिकल 22 क्लास 2 अनुच्छेद 22(2). इट मैंडेट्स, ये आदेश देता है कि आफ्टर अरेस्ट ऑफ ए पर्सन अक्यूज्ड ऑफ सम ऑफेंस, his detention in police custody cannot exceed 24 hours. Police are bound to produce the accused before the nearest magistrate within a period of 24 hours from the time of arrest. This provision 22 clause 2 is in the constitution. (22). What is the ordinary statutory provision in the BNSS in the CRPC? Earlier in the CRPC it was section 167. You can say section 167 of the CRPC was just expansion of the article 22 clause 2. The new section for this 167 of the CRPC in BNSS is 187. 167 has now become 187. Go to the schedule given in the beginning of the BNSS. You will find the 167 has now become 187. This 187 by and large contains the same provisions. If the investigation could not be completed within 24 hours, the bounden duty of the arresting officer is, police is, to produce the accused before the nearest judicial or executive magistrate. Firstly, the judicial magistrate, and if he is not available, then before the executive magistrate for authorization of his further detention. But this detention must not exceed 15 days in one go. 15 दिन से ज्यादा वो नहीं देगा. एक नया उन्होंने अब जोड़ दिया है कि इसमें 187 of the BNSS has now given more power to the magistrate. If the arresting officer justifies, he produces the material which justifies the detention beyond 15 days. So the magistrate can remand of the accused exceeding 15 days, but he must not exceed the outer limit of 60 or 90 days as the case may be. You know, if a charge sheet is not submitted to the court by the investigating officer within a period of 60 days, where the offense does not exceed punishment beyond 10 years or up to 10 years, then 60 days. And if the offense is punishable with 10 years or more imprisonment, then 90 days. Otherwise, accused will be set free. He will be granted statutory bail, default bail. Under earlier, this bail was granted by courts under section 167, subsection 2 of the CRPC after expiry of 60 or 90 days. And that bail is not granted on merits of the case. That is absolute right of the accused. If the IO failed to submit charge sheet to the court within 60 or 90 days, as the case may be, then accused gets absolute right to be released on bail. Duty of magistrate is to point out this right that has accrued in favor of the accused. The accused need not move even formal written application. He can verbally request the magistrate, please magistrate, I'm not moving any application, but as I have got this absolute right in my favor to be released on bail, because the IO has not been able to submit the charge sheet within 60 days or 90 days, whichever is attracted to the case. Therefore, I should be good. Even in the absence of application from the accused, my state duty bound to order his release. No reasons will be recorded. There is no necessity to refer various relevant considerations which weigh with the courts for granting or refusing the bail. It is absolute right, statutory bail, default bail. Now this section has become a section in the BNSS in the F.I.R 187. The same provisions are there. If you want to study this statutory bail, default bail in detail, please consult my website. You can note down this website, lawhelpline.in, LAW, small letters without space, lawhelpline, LINE.in, lawhelpline.in. You can now search this website on Google. It will open with my name, BNSS Upadhyay, and it will take you to that website. It contains more than 10,000 pages, covers some 200 law subjects with latest updated material, the latest pronouncements of the Supreme Court, and if Supreme Court is not available on that subject, then of any other high court. So this website is hugely, largely consulted by the judges, magistrates, lawyers, and of course, many law professors, law students, competitive students sitting in various competitive public examinations taking the law subjects. They consult this site. If you are so far not familiar with this website, you can consult it and you can open the subject of your choice, file of your choice. If you want the method of searching a particular point in that file, in that article, you can search, insert a particular word to search, and it will directly take you to that point, and you will find the solution of your problem with the citation of Supreme Court judgment. So I'm again repeating the name of my website, lawhelpline.in. I think the organizer of this program will share this website with you by mail or WhatsApp, whatever mode is possible for her. All that I'm telling you here in this session regarding remand, registration of F.I.R, direction of magistrate for registration of F.I.R, investigation of NCR, etc. All these things are available on this website. If you open the law of bails applicable to sessions courts, law of bails applicable to magisterial courts, these are the names of files, subjects on this website. You will find that Lalita Kumari case, Constitution Bench of 2014, wherein guidelines of the Supreme Court are available. So since the provisions regarding arrest are the same even now, that law laid down by the Supreme Court Constitution Bench in 2014 in Lalita Kumari continues to be a valid law. You can cite it. Police have no unfettered, unchecked, arbitrary power to make the arrest. They will have to justify in the arrest number, as I pointed out earlier. Then how the investigation is conducted, manner of investigation. The emphasis in the new law, BNSS now is to make maximum use of scientific methods, electronic devices, wherever necessary, wherever possible, for purpose of investigation of crimes. You know, police or other agencies are there who are empowered in the BNSS to investigate the offences. No third degree method is permissible. Tortures are not permissible. Now somebody may put a question to only yesterday 3 accused persons in the Haryana were killed in some police encounter. Have you heard this news? Yes, Altraj were killed only yesterday in an encounter with the police in the state of Haryana. Did you notice this news? Since yesterday night at about 11, I came to see this news item on different channels. Today in newspapers, this news is there. Anyway, the statutory prescription in the BNSS is to use scientific methods, to use electronic devices by the investigating agencies, investigating officers, to ensure that the investigation is completed in a proper manner. No material evidence is left out. A duty has been cast upon the investigating agency under Section 175 of the BNSS. Earlier in the CRPC, the relevant section was 156 and onward. Now, the section of investigation is 175. Almost same provisions are here. Certain new directions in the form of law have been added in 175. If a police officer is investigating offenses, sexual offenses, commission of sexual, an incident involving commission of sexual offenses under the defined in the Bharatiya Nyaya Sanhita, then investigation must be completed within a period of 2 months. विवेचना कितने दिन में हो जानी चाहिए? Within a period of 2 months. If the police are investigating an incident involving sexual offenses against women, 2 महीना का पहले टाइम लिमिट नहीं था, टाइम लिमिट. तो इस सब टाइप के थोड़े थोड़े उसमें चेंजेस हुए. फिर आफ्टर कंप्लीशन ऑफ इन्वेस्टिगेशन व्हाट कैन हैपन? Police will submit police report to the court, to the concerned magistrate's court. Earlier in CRPC, the relevant section was 173(2). Under this section, police would submit its report, what is called police report. In ordinary parlance, in practice, this police report is called charge sheet or final report. Investigation will either end in the charge sheet against the accused or in the form of final report. If no evidence is found during investigation and no prima facie case is found to be made out by the police, then police will submit to the court the final report. And if evidence is found, accused is prima facie found to be guilty, then charge sheet will be submitted by police. This charge sheet or this final report is called police report. Police report within the meaning of section 173(2) CRPC means charge sheet or final report. Word charge sheet, word final report to CRPC. The same provision they have borrowed here in section 193. That 173(2) has now become in the BNSS 193. And if during the course of investigation or submission of charge sheet or the final report, the police officer comes to the magistrate with his application under section 178, 173, subsection 8 for further investigation, magistrate would normally pass the order directing the police, authorizing the police to make further investigation. The similar provision has now been retained in the form of this section 175. So after investigation, charge sheet is submitted to the court or final report is submitted. When a charge sheet is submitted, then court proceeds to take cognizance of the offense and issues process summonses to the accused persons to appear and face the trial. But if final report is submitted, then what are the options of the magistrate? There are 4 options. One is the magistrate may accept the final report, may drop the proceedings finally. Number 2, magistrate may reject the final report and take cognizance of the offenses, provided there is evidence in the case diary, in the police report submitted by the police, making out prima facie case regarding commission of offences. So when a prima facie case is made out of evidence in the case diary, magistrate won't accept the final report. Magistrate treating the final report, police report, as charge sheet and may issue the process to the accused to appear and face the trial. Third option available with the magistrate is he may issue, if the magistrate thinks yes, this final report deserves to be accepted. So before accepting the final report, duty of magistrate is to issue notice to the informant. In the matter of your F.I.R, police have submitted final report. If you want to make any objections, protest petition, you can make your protest petition, your objection to the court by date so and so. And if the informant appears with his objection, the magistrate will then examine the material in the case diary. And if he is convinced, yes, there is force in the objections of the informant, because there is evidence in the case diary prima facie constituting certain offences, then magistrate will reject the final report, will take the cognizance. In that way, the protest petition of the informant shall stand allowed. Now, next option, 4th option is to treat the protest petition or objection of the informant as complaint case. In the CRPC, magistrate could have then proceeded under section 200, 202, 203, 204 in the old CRPC, outgone CRPC. Analogous corresponding section in the present BNSS is R 200, 223. Section 200 of the CRPC has now become in the BNSS section 223, 223. The provision is the same. One rider they have added now in section 223 in the BNSS, that after recording the statement of the complainant and his witnesses, the magistrate would not outright proceed to dismiss the complaint or summon the accused, take cognizance and issue the process to the accused. Before taking cognizance of the offences and summoning the accused, issuing the process, duty of magistrate is to issue notices to the proposed accused persons in the complaint case. If you want to protest, to raise your objections, you may come. You have got a right to be heard, magistrate, and if the proposed accused appears, participates in the hearing, then the magistrate will hear the complainant or his counsel and the proposed accused and or his counsel. After hearing the accused, magistrate will pass the summoning order if there is evidence brought on record by the complainant and his witnesses under section 200. So this is a new provision, a new duty, a new obligation has been passed by the parliament upon the magistrate in a complaint case. Earlier, there was no such provision in the CRPC under section 200, 202, 3, 4. There was no such provision to hear the accused before passing the summoning order. But now, before passing the summoning order, this duty has been passed upon the magistrate. Before taking cognizance, before issuing process to the accused, the magistrate will issue notice to the proposed accused, will hear him also. Now I will switch over to bails. You know, in the CRPC, provisions for bail, sections for bail were sections 436, 437, 437A, 439, 438. If it is anticipatory bail, then 438. Otherwise, for the rest of bails, 436, etc. If the offence is bailable, then in CRPC, provision was for grant of bail under 436. Now this 436 has become 478. I have noted down these sections on a piece of paper. You can find these new sections in the BNSS in the schedule given in the beginning of the Sanhita, BNSS. This 436 has now become 478. It relates to the bailable offences. When an offence is bailable, the accused is entitled to bail as a matter of right. Magistrate or court do not have any discretion for refusing the bail. Article 21 is there in the Constitution. It says that personal liberty is a fundamental right. It's also a human right. That Universal Declaration of the United Nations made by it in its Universal Charter of Human Rights on December 10, 1948. There are 30 articles which provide for different types of fundamental rights, human rights. All those human rights have been incorporated in our Constitution, and those particular articles are Article 21. It starts from 20, 20, 21, 22. They deal with the liberty as fundamental right. Outside Constitution, this right is called human right. And once incorporated in our Constitution, they are called fundamental rights under Part 3rd of the Constitution of India. You know what are fundamental rights there. Need not elaborate it at length. So this law of bail is the progeny of Article 21, protection to personal liberty. So when the offence is bailable, what offences are bailable? You know, in the IPC or now in Bharatiya Nyaya Sanhita, there is a schedule. It defines, provides which offences are bailable, which are non-bailable. And if there is no such provision given, then an offence punishable with imprisonment up to 3 years or more would be treated to be non-bailable. If you want to see this law, which is from the Supreme Court, you can consult an article, a file of mine available on my website, lawhelpline.in. Bail by my state, bail by sessions court. So clearly these sections provide, yes, what are bailable and what are non-bailable. In bailable offences, there is no problem. Bail has to be granted as right. In non-bailable offences, in CRPC, there was section 437 for my state. Now that 437 has become 480. Almost the ground of grant or refusal of bail by my state in non-bailable offences are the same, which were there in the 437. Now in 480, the basic law has not changed. It is the same. The considerations for grant or refusal of bail in non-bailable offence by my state under 480 under BNSS are the same as they used to be under section 437 in the CRPC. Then for sessions, it is section 483. You know, in CRPC, for High Court and for sessions judges, the section for bail was 439. This 439 has now become 483 in the BNSS. Provisions are almost the same with certain guidelines, additions, new guidelines. What has been added as new provision in section 483 in the BNSS is that if the bail application has been moved by the accused for bail in relation to offences involving sexual offences against women, then duty on High Court or Session Judge has been cast that the Session Judge or High Court before whom the application has been moved will issue a notice to the public prosecutor, and 15 days prior notice is the provision in 483. So that during this period, the public prosecutor may prepare his response, his objection, and may place it before the court at the time of hearing of the bail application. Another new provision is that if the victim of the offense, sexual offense, is a lady or any person, even male is victim of, so a duty has been cast upon the High Court or the Session Judge to issue him or her a notice to appear, so that if he or she wants to oppose the bail application, he may oppose it. So with these two riders, 15 days notice to the public prosecutor and a notice to appear and to be heard to the victim. Informant word is there under this 483. Informant could be any person. Suppose if a lady is victim of some rape, so an F.I.R has been got registered with the police by some stranger, and the stranger is not interested in opposing the bail application, and the court has simply issued its notice to the informant. Informant means the person who had lodged the F.I.R. His name is written in the F.I.R. So this informant in reality, in practice, in effect would be, the correct meaning of the informant would be the victim of the offense. If the informant, despite service of notice, does not appear, does not participate in the hearing, does not oppose, then what is option left with the court? To issue notice to the victim, because who is the aggrieved person? Informant was not the aggrieved person, affected person by the crime. It was that lady. Who is the real informant? Who is the victim? The informant word means here victim. It's not a word of literature. It's a word of law. It has a particular object, intent, objective to be achieved behind this provision in the new section 483 in the BNSS is to ensure that the victim gets informed. And if she wants to oppose the bail application, she may appear before the court and may oppose it, may participate in the hearing. Then what are the relevant considerations which are taken into consideration for grant of bail or refusal of bail? I would suggest you to go to my article, Law of Bails, or my state's another article, Law of Bails for Session Judges. Very, very detailed articles with all the latest leading judicial pronouncements of the Supreme Court. If you want to gain mastery in the matter of law of bails, I would suggest you to consult my website, and if you go once through this article, twice, thrice, you will have absolute clarity to what are the parameters, guidelines of the Supreme Court, which should be applied in granting or refusing the bail. Then there is 438, anticipatory bail. I have given a complete material, a file, article on this website, anticipatory bail under 438. I will suggest you to go through this also. So I will now take you what happens after taking cognizance of the charges. Now, offenses, when a charge sheet is submitted to the court, the first step is to take cognizance and issue notice to the accused to procure his appearance. And when the accused appears, then in compliance with section 207 of the CRPC, there is another corresponding section now in the BNSS. The copies of the charge sheet, F.I.R, case diary, whatever material the investigating agency had collected during investigation, its a copy will be provided to the accused. Then what would be the next proceeding? Charge or discharge of the accused. Once copies of the police report in charge sheet and case diary is provided to the accused, court will fix a date for hearing on charges. Here accused has got a right to be heard. He can move an application, or even without moving an application to the court, he can make his verbal submissions to the court. Yes, honorable court, look here. As per the material contained in the case diary in the police report, no prima facie case is made out against me for framing the charge. And if his submissions are acceptable, there is force into his submissions, and there is no evidence in the case diary in the police report, the court will discharge the accused. But if there is evidence constituting prima facie the cases under different penal sections against the accused, court would frame the charges. So first, it is discharge. In old CRPC, there was in warrant trial cases 239. You know, my state conducts warrant trial. In summon trial cases, charges are not framed. In warrant trial, charges are framed. If under section 239, my state was not convinced with regard to commission of making out of prima facie offense, my state could have discharged. Now for 239, there is a different section. And if my state is of the view, yes, there is evidence, there is material in the police report, in the case diary, he would frame the charge. And in CRPC, the section under which my state would frame the charge, that was 240. For 240, now it is 263. In BNSS, it is now section 263. If out of material in the case diary, prima facie case is made out, then my state would frame the charge of that penal. Same is the position with the session judge. For session judges in the CRPC, there was section 227, for which now there is section 250. If out of material in the case diary, no case is made out for framing the charge, session judge would discharge the accused. And if material is there constituting prima facie case for framing the charge, under section 228, 228 of the CRPC, session judge would frame the charge. In BNSS, for this new section 228, new section is section 251. 228 क्या हो गई? 251 हो गई. तो ये charge discharge का ला हुआ. Now I am taking to you to a other section, section 309 CRPC. You know what is 309? Adjournments. In CRPC, this section provided, still provides, even after repeal, because you know CRPC will be applied in old cases, all those pending cases which were pending on June 30, given that section 531 of the BNSS, all those cases which were pending by June 30, CRPC will apply to them. So CRPC has gone nowhere. It is very much alive despite repeal in pending cases up to June 30. BNSS will apply only to those cases those trials, appeals, applications, proceedings which came into existence for the first time on July 1. So I'm telling you about section 309 of the CRPC, day-to-day trial. And if for certain good reasons, some proceeding could not be undertaken on a given date, on a fixed date, court had power to adjourn the case to some other date. This 309 has now become 346. 309 क्या हो गई सीआरपीसी की? बीएनएसएस में आके क्या हो गई? 309 346 346. This 346 says any adjournment of proceeding would be made, adjournment would be granted only for exceptional reasons, when the things are beyond the control of the party seeking the adjournment. Only then court would grant the adjournment. Means seeking adjournment has now become a tough thing for the parties. The idea behind this provision in BNSS is to ensure that the trial of cases is speeded up. No unnecessary time is consumed in the trial, and the cases, criminal cases are decided expeditiously to cut short the delays. तारीख पे तारीख को खत्म करने के लिए, जल्दी से केसेज में जजमेंट फैसला करने के लिए, न्याय देने के लिए ये हुआ है कि no party will seek more than 2 adjournments if the witnesses are present. If recording of oral evidence of the witnesses have started, then no party shall have right to seek more than 2 adjournments. What would be the impact of this harsh provision? It's a very, very harsh provision. So far, under old CRPC, under section 309, the council had freedom to seek as many adjournments as he wanted. Now, this liberty has been curtailed. Adjournments have been limited up to 2. Witnesses का examination शुरू हो गया, witness आया हुआ है, तो 2 से ज़्यादा कोर्ट नहीं ग्रांट कर सकती. And that too, when the party satisfies the court, he is seeking adjournment because the things are beyond his control. Means some close relative or the accused himself is hospitalized, he cannot move, or for certain other compelling reasons, he cannot come to the court and could not instruct his counsel, whatever might be the reason. And when the court is satisfied that, yes, things are beyond the control of the party, therefore, it is proper to grant him adjournment. So, under such situation, 2 adjournments can be granted. And if a witness is present in the court, suppose a prosecution witness has come, but the defense counsel is not present, then this section 346 of the BNSS provides court can close the evidence. Court can record the examination in chief of this witness. The public prosecutor can examine his witness. Court would record his deposition. And if the counsel for defense doesn't appear to cross-examine the witness, court may close. Another rider has also been added. The ground that the counsel for the accused is busy in some other court, not accused party. If the counsel for the party is busy in some other case in some other court, it would not be a ground for granting the adjournment. The very rigorous provisions, harsher provisions have been incorporated in the new BNSS in the form of section 346. Now this section is going to trial. तोप बन गई, टैंक बन गई, फील्ड में ट्रायल होगा कि नहीं? फैक्ट्री से निकली बिना ट्रायल के मोर्चे पर लगा दी जाएगी. पता चला गोला उधर फेंकना है, इधर फेंक दी. So now this embargo, this limitation, restriction imposed upon the counsel, the advocates, not to seek more than 2 adjournments, has to be tested in our judicial system. There are a few judgments of the Supreme Court passed in the past which have laid down that lawyers have got no right to go on strike, to abstain from judicial work. Once they are engaged by the party. They are duty bound to appear before the court when the case is called up and taken up. You must have heard only for the last 2-3 days, the High Court Bar Association of Allahabad High Court was on strike. A division bench of the Allahabad High Court had issued notices to the Bar Council, to the Bar Association office bearers and District Court Bar Association office bearers in Allahabad. Why they have gone on strike, abstaining from judicial work by flouting the directions of the Supreme Court in such and such cases. If you want to know about these directions of the Supreme Court, these cases regarding advocates, strikes, etc., I would suggest you to consult my website, lawhelpline.in. There is an article, elaborate article of mine, Advocates and Attorneys is the name of that file, that subject. If you consult it, you will find all these cases which I am telling you. So let us see to what happens. This adjournment section 346 empowers the court to close the evidence and pronounce the judgment. A closure of evidence would mean in many cases that the material evidence could not be brought on record because of limit up to adjournment, because the court closed the opportunity of leading the evidence to this party or that party, prosecution or defense. So closure may result into derailment of justice, because after closure of the opportunity of evidence, what can be done by court? Judgment may be pronounced. Case may be speeded up and judgment may be pronounced. Whether the duty of court is to merely pronounce the judgment or to do justice. What is the difference between judgment and justice? Justice is the soul of judgment, just like in a body of a living being, human being or any other living being. Soul, it is the soul that is running his life. A body without soul is a dead body. So is a judgment without judgment a waste piece of paper. But leave it to the wisdom of the legislature. How this section is interpreted, this provision regarding limiting the adjournment up to 2 is interpreted by High Courts, by Supreme Court. It's an interesting matter to be watched by us in future. I would draw your attention to a case of 2005. You know, CPC, Code of Civil Procedure 1908, CPC, was drastically amended by Parliament with effect from July 1, 2002. In Order 17 in the CPC, the maximum number of adjournments to be granted by civil courts was limited up to 3. यहाँ 2 किया है तो वहाँ 3 किया. This was challenged by the Salem Advocates Bar Association in the Supreme Court. Then a 3-judge bench of the Supreme Court in the case of Salem Advocates Bar Association versus Union of India ruled that all the amendments in the CPC made by Parliament with effect from July 1st, 2002 were only directory. They were not binding, not mandatory, not absolute. And if there are justifiable reasons, court may grant as many adjournments as court thinks proper. I think that the same will be done to this section 346 by the Supreme Court. That Salem Advocate Bar Association 3-judge bench will be cited. CPC is also a procedural code. So is your BNSS procedural code. How can you limit the discussion of the court? Its meaning, true meaning, real meaning, I think it would be if the grant of adjournment is justifiable beyond 2, court would have every right to grant more than 2. But let us see. Suppose the evidence is collected, compiled, then what is done? When prosecution completes produces its entire evidence, then a statement of the accused persons is recorded under section 313 of the CRPC in old CRPC. For that section 313, now it is section 351 in the BNSS. The provisions are the same. One thing has been added. The earlier public prosecutor was required to assist the court in preparing the questions to be put to the witness to seek his response. Now this duty has been passed along with the public prosecutor on the defense counsel also. Now public prosecutor and defense counsel both will assist the court in formulating the questions to seek answer or response of the accused on the incriminating pieces of evidence which have appeared in the depositions of the prosecution witnesses or in documents produced by the prosecution against the accused. You know what is the purpose of statement of accused under 3? Purpose of statement, recording of statement of accused under CRPC under section 313 or now in BNSS under 351 is to seek explanation of the accused on those evidences which have been brought against him by the prosecution, so that the version of the accused may be considered by the court at the time of trial or at the time of judgment. Then there is a section 482 CRPC in the old CRPC, 482 in old CRPC. It is meant for High Court, inherent power of the High Court to pass any order in order to advance the cause of justice. The corresponding section now in the BNSS for 482 of CRPC is 528. It is not meant for session judge, for magistrate, for district court. It is meant for High Court. Almost the same provisions are there. There is no change. Earlier it was 482 in CRPC. Now it is 528 in your BNSS.
What are the obligations on electronic FIR process?
Yes, now this BNSS has given option to the informant to lodge his FIR by any means of electronic devices, email, WhatsApp, or whatever electronic mode available is known, or he can even personally present himself before the SHO in the police station. He may move his written application, but side by side, all the electronic modes, electronic devices can also be applied by an informant for purposes of lodging his FIR. 556 is perhaps the section in new BNSS which says that the notices, processes which are generally issued to the witnesses, to the accused, may be issued through electronic devices, means mail. The charge sheet by the investigating agency can be sent to the court through electronic device, means mail. What could be the mode as of now? The mail. Otherwise, you know, why would the personal mobile number of the court of the judge or magistrate will be used for sending the charge sheet or process or any report on his personal mobile number? So ordinarily, every court has got email ID. Every police officer is supposed to be familiar with it. He can send it, and if it is available on the site of the court, even the parties can move their application, their revision, their appeal through email. This BNSS has provided great facility, great opportunity to the litigants community, to the party, to their counsel, public prosecutor, to make their submissions. One need not to be present physically before the court to make his submissions. Though he can come to the court physically and submit his arguments, he can also submit his written argument. But if he want to stay away from the court, he can electronically address the court by electronic device, means video conferencing or whatever mode is available, or he can submit his written argument through mail. So is the case with the police. If the police want to send a report to the court, need not to be physically present and then submit it to the court. They can apply any mode which is available as of now through electronic devices. That can be applied. So this is the new facility, new provision in this new BNSS.
What are the stages after issuance of process under section 304 CRPC and now with BNSS?
304, earlier that was 204. In old CRPC, it was section 204 that was applied by the magistrate taking cognizance and issuing process to the accused. Now that 204 has become 227, 227, 227. The provisions are the same. The procedure is after passing the summoning order, the magistrate issues the process. In first instance, the magistrate cannot issue warrant, available or non-available warrant. His duty is, after taking cognizance and passing the summoning order in a complaint case, he has to issue the summonses to the accused. And if after service of the summonses upon the accused, it does not appear as, or earlier you go to that section. I had pointed out to you section 200 of the CRPC that has now become 223. It has added a new provision. After examining the complainant and his witnesses and recording the statement of the complainant and his witnesses, if the magistrate is of the view that a prima facie case is made out and magistrate wants to proceed under section 204, now in BNSS it is 227, then the magistrate would not outright pass the summoning order. His duty is first to issue a notice to the accused. He will hear the accused, proposed accused, and if after hearing the complainant and the proposed accused or their counsel, magistrate is still of the view that a prima facie case is made out, then magistrate would pass the order. And if the accused is then not in appearance, magistrate would then issue the summonses requiring the accused to attend the court on a date. And once he comes, then process will go ahead. After summoning order, what happens? Under section 244 CRPC, now there is a corresponding section in BNSS. Under this section, the statement of the witnesses and complainant will again be recorded.
In your opening statement, you said the older laws of Indian Penal Code CRPC, Indian Evidence Act, were from Britishers, and the prime reason was to subjugate the subject under the British rule. That means by default they considered themselves superior, and the law enforcing authorities were superior, whether it is government, whether it is police, or whether it is a government servant. Now, if they say Bharatiya Nagrik Suraksha Sanhita या Bharatiya Nagrik, how is it different from the IPCs when नागरिक को superior बनाया गया है and government servants को, law enforcing authorities, police को और सबको equal platform पे रखा गया जहाँ even they are answerable और वो दंडों से नहीं हरकाए या corruption करके नहीं हरकाए नागरिकों को. ये फर्क आप बताइए, क्या फर्क है?
You can criticize this new law in the manner you criticized it now. No law can be absolute. Only divine law is absolute. A man-made law is always deficient in some form. कुछ ना कुछ उसमें खामियां कमियां रही जाएंगी. तो इसलिए थ्योरी क्या है हमारे यहाँ कि legislative wisdom cannot be questioned. Who is supreme in the matter of legislation in making the laws? Given the demarcation of powers under the scheme of our constitution, there are three pillars organs. Executive, legislature, and judiciary. The constitution has assigned the power of enacting the laws to which organization, to which institution? Parliament, legislature, state legislature, or union legislature? Parliament. Court has many times ruled in many cases that it is for the legislature to amend the law. Unless a provision of any law made by parliament or state legislature is constitutionally invalid, ultra vires, it has to be respected, it has to be implemented. And so long as it is not declared by the High Court or the Supreme Court to be constitutionally invalid, constitutionally void law, it is binding. A citizen has all the right of speech and expression within the meaning of Article 19(1)(a) of the Constitution of India to criticize any law, to criticize any judgment, and unless the law is criticized, unless the judgment is criticized, or this right is not given to the citizens, how the law will evolve? Then a fair criticism is part of fair play of our system. Constitution permits so long as there is no malice, there is no malafide on the part of the critic.
My question was, अगर इसको भारतीय नागरिक सुरक्षा बोल रहे हो तो आप नागरिकों की इज्जत के लिए क्या कर रहे हो? आप तो बाय डिफॉल्ट पुलिस को सुपीरियर बना रहे हो, आप बाय डिफॉल्ट गवर्नमेंट सर्वेंट्स को सुपीरियर बना रहे हो. तो आपके ये लॉ और जो आपका ओपनिंग स्टेटमेंट था कि ब्रिटिशर्स ने जो लॉज बनाए थे सब्जुगेट करने के लिए प्रजा को, दोनों में क्या फर्क है सर? मैंने खुद में कितनी चीजें पढ़ी हैं इसमें नए वाले में. वसुदेव कुटुंब की कहानी कहते हो आप, ना तो यहाँ पे एनिमल्स की इज्जत करते हो इस कंट्री में, ना ट्रीज की करते हो, ना नागरिकों की करते हो. आप अपने आप को सुपीरियर बना रहे हैं. इट इज लाइक मैं ही जज, जो राजा अपने लिए लॉ बना रहा है लेकिन राजा के लिए कोई लॉ नहीं है सर. और आपको पता है कि जुडिशरी किस तरह से चलती है, पुलिस किस तरह से चलती है, पब्लिक सर्वेंट्स किस तरह से चलते हैं सर. मेरा वो आपसे समझने का रिक्वेस्ट था कि क्या इज्जत मिल रही है नागरिकों को नए लॉ में और पुराने लॉ में हटाने से कौन सी इज्जत घट गई है नागरिकों की? They were treated like filth and they are treated like filth in future also, sir.
Let me add a few words to your observations. First, you have every right to find out the deficiency, the shortcomings in the new laws. Constitution permits it. Number two, it has just been put into operation from July 1. The deficiencies, shortcomings in these new laws will now come to be tested by courts, by the agencies, by all those stakeholders who will use this law. The bar associations, lawyers are the biggest stakeholders of this law. Then agencies like police and others are there. Then judiciary is there. So the efficacy of this law, this new law, will now be tested in courts. And I think if your concerns are genuine, then courts and all other stakeholders will gradually come to identify the shortcomings and will highlight it, and then courts will intervene. You know, many a times Parliament suggests, the Supreme Court suggests the Parliament to remove the deficiency, the shortcomings in the laws, to amend the laws, to make them more effective, more citizen-friendly, more fruitful. But still, who will amend the law? Who has the power to amend the law if there is any deficiency? You know, the Parliament, the state legislature, which had enacted the law. If the state legislature had enacted that law, then of course, on the suggestion of the courts or on its own, legislature does have the power to amend the law, to remove the deficiency, the defect, if any. And I can say only this much: your concern must find echo with the courts, with the stakeholders like lawyers, and if you are yourself a practicing lawyer, you must, in some cases, raise it before the High Court, before the Supreme Court, because only these two courts of records do have the power to interpret the law. Otherwise, you know, the lower court is bound by the interpreted law, which is available from the Supreme Court or from the High Court. And you know, broadly we have four major criminal laws of British origin. Police Act 1960, it has not been amended. 1860. How old is this police law in this country? Some 145 years. Police Act of 1860. So nearly after 145 years, this country has not amended the British era Police Act. Why? You should put a larger question, and I think you will be then justified in putting a question. To when IPC, CRPC Evidence Act was being amended, why this Police Act was not amended? I also put this question to many stakeholders, so nobody has answer to it. Many things are done in questionable manners, sometimes by the police, sometimes by the other. That problem is there, but still, legislative wisdom cannot be questioned. So long as the law is not amended, you are bound to abide by the existing law. आज की तारीख में जो कानून है, हम उसको सेमिनार में इस तरीके के प्रोग्राम में तो भले क्रिटिसाइज कर लें, लेकिन जब किसी गिवन केस में उसको अप्लाई करना होगा तो हम उसकी यह आलोचना करते हुए उसको अप्लाई करने से मना नहीं कर सकते हैं कि ये लॉ हमको पसंद नहीं है, इसलिए हम इसको अप्लाई नहीं करेंगे। हम सजेस्ट कर सकते हैं, आलोचना कर सकते हैं, लेकिन जब तक वो लॉ अमेंड नहीं होगा तब तक हम क्या करेंगे? वही जो मौजूदा लॉ है वही हम पे बाइंडिंग है, वही कोर्ट पर बाइंडिंग है, वही एजेंसीज पे बाइंडिंग है, लायर से लेकर के सब पर बाइंडिंग है, देश पे बाइंडिंग है, क्योंकि आलोचना से लॉ नहीं बदलेगा, आलोचना से अवसर मिलता है, प्रेरणा मिलती है लॉ को अमेंड करने की, और अमेंड तो वही करेंगे जिन्होंने बनाया है ओरिजिनल लॉ, पार्लियामेंट। तो इसलिए लेट अस होप कि आपकी कंसर्न पार्लियामेंट तक पहुंचे और ये लॉ अमेंड। तो मैंने अरेस्ट पर आपको कुछ इस तरीके से चीजें बताई।